So the issue of concealed carry bans is once again back in the hands of the Supreme Court. This is a direct result of multiple states directly defying what the Supreme Court said in Bruin. So let's talk about what is now happening. Now, real quick before we jump into this video, I want to ask you all for a huge favor. Looking at some of my analytics, about 60% of all my viewers are not actually subscribed to the channel. So if you enjoy this type of content, if you enjoy this information and you want it to get out to more people, please consider subscribing to the channel. That really does help the channel to grow and for this type of information and for these videos to get out to more people. But regardless, thank you guys so much for all of your support. As I mentioned in the intro, in this video, we're going to be discussing how this issue of concealed carry and the Second Amendment is once again in front of the United States Supreme Court because the state of New York and other states like California continue to directly defy what the Supreme Court said in Bruin. You may recall that recently, 5 cases had expedited hearings before the Second Circuit because of a recent warning that the Supreme Court issued to that Second Circuit. The 5 cases challenged New York's Concealed Carry Improvement Act, also known as the CCIA. That New York law created a hyper-restrictive concealed carry law that directly was in response to what the Supreme Court said in their New York State Rifle and Pistol Association versus Bruin decision. That was a landmark 2A case, but just 8 days after the Supreme Court issued that decision, New York responded by passing a new law. The state of New York and the Second Circuit continued to defy what the Supreme Court said in Bruin, and they continued to violate the Second Amendment. And in response, Gun Owners of America, or GOA, is now asking for the Supreme Court to step in. They're asking for the Supreme Court to review the Antonyuk case and once again strike down what the state of New York is doing as far as their concealed carry restrictions. But the state of New York is now fighting back, and they're arguing that the Supreme Court should completely reject review of this case and should completely just avoid this issue. Now, in Bruin, the Supreme Court struck down New York's original May issue CCW licensing scheme, finding that it was inconsistent with this nation's history and tradition. One of the primary findings of that Bruin decision was that the government bears the burden to prove that their restrictions are based in the history and tradition of our nation and that they date back to 1791. But another important thing that the Supreme Court did in that opinion was that they stated that a state like New York could not simply make everywhere a sensitive location. However, despite that decision, the state of New York rushed through the Concealed Carry Improvement Act, the CCIA, which made the permit scheme in the state even worse than the one that existed prior to Bruin. Now, this law was challenged in multiple cases and in multiple district courts, and there were some district courts that granted preliminary injunctions, essentially halting the enforcement of the CCIA, but that was just a temporary form of relief. It's just a preliminary injunction. However, the state of New York appealed those preliminary injunction decisions up to the Second Circuit, who then granted blanket stays on those decisions. So they just said, no, we're going to halt those favorable decisions. We're going to put a block on the preliminary injunctions. Now, in response, Gun Owners of America in the Antonyuk case originally sought emergency review from the Supreme Court. So that's the first time they went to the Supreme Court. The Supreme Court, on review of that emergency application, denied emergency relief, but in that same order of the court, they did state that the Second Circuit cannot simply drag their feet on this issue. Justice Alito, through that opinion, stated that either the Second Circuit would need to issue their own decision on why they granted that stay, or they would need to expedite hearings in those cases. And if they did not, if the Second Circuit continued to do the wrong thing, well, then the plaintiffs there, GOA and Antonyuk, could go back up to the Supreme Court. Now, recently, the Second Circuit held oral arguments and hearings in these cases and then issued rulings in 5 of the CCIA cases. That was back in December. The big argument really came in the Antonyuk case, which is the one that was argued by GOA. The Antonyuk case was a challenge to the CCIA at large, which included a challenge to the CCW processing scheme, the whole procedures there, and then also the catch-all sensitive location bans. The Second Circuit ultimately on review vacated some of the district court's injunction against the enforcement of the CCIA. So essentially they overruled some of the things that the lower court said and were going to let the CCIA go back into effect. In their decision, the Second Circuit distinguished Bruin as an exceptional case. That is exactly what they said. And in their opinion, the Second Circuit said that Bruin and its rationale and its analysis was distinguishable from what was going on here in the CCIA case, and that Bruin did not apply to this case at all. Now, in response to this Second Circuit ruling, GOA has now filed for a writ of cert to the Supreme Court, so they filed a petition for Supreme Court review. Although the case is still in an interlocutory posture, the fact that this deals directly with Bruin and that decision And what New York did in direct response to Bruen makes it a strong candidate for Supreme Court review. But again, it's in an interlocutory posture. Also, the fact that the Supreme Court has prior stated in this specific case that there is a potential for reconsideration if the Second Circuit did not handle this case appropriately also adds some support for the petition here. In this petition, GOA directly points out that the Second Circuit, along with other lower courts, continue to directly defy what the Supreme Court said in Bruen. GOA states that, repeatedly, the panel advanced the remarkable theory that it was not bound to apply the court's methodology in Bruen. Labeling Bruen a case of exceptional nature, the panel surmised that the courts are not required to follow Bruen's lead in cases challenging less exceptional regulations. The panel repeated this claim no fewer than 4 times, each time justifying circumvention of a portion of Bruen's framework on the theory that Bruen came out the way that it did only because it was exceptional. Now, the outcome of the New York case is very important, not just for the state of New York, but other states like California, who are facing similar regulations and similar concealed carry restrictions. For example, California through SB 2 put in place a similar restriction. California passed that similar law just a year after Bruen, and right now CRPA is filing a lawsuit. It has filed a lawsuit against SB 2. Myself and Reno May are currently plaintiffs, and that's currently being reviewed in the Ninth Circuit. And the outcome of what happens here in the New York case is going to impact what also happens in the Ninth Circuit, because oftentimes the Ninth Circuit will in fact just follow what the Second Circuit said. And even, recently in the oral arguments, the Ninth Circuit alluded to the fact that maybe they should just follow what the Second Circuit did. But in response to this petition, the state of New York has also responded by arguing that the Supreme Court should completely just reject review of this case right now. They argue that this issue is too premature for current Supreme Court review, and that currently there is no circuit court split on this issue, and therefore there is no justification for review in this case. In their response, the state of New York argues that the petition for certiorari should be denied. As an initial matter, this court's ordinary practice of denying interlocutory review is especially advisable here, where the Court of Appeals merely found that the plaintiffs did not establish a likelihood of success on the merits at the preliminary injunction stage, either for lack of standing or for lack of meritorious legal claims. So the first thing that New York tries to do in their response brief essentially just lean heavily on the fact that the Supreme Court does not like to review cases at early stages. They do not like preliminary injunction reviews. They do not like interlocutory cases. So they're leaning heavily on that to avoid review by the Supreme Court. The Supreme Court, again, traditionally does not like these types of reviews. They like final merits decisions. They like circuit court splits on issues, and that's traditionally when they will grant review. Now, the state also goes on to argue in their response that no petitioner has applied for a license under the challenge licensing scheme, much less been denied a license based on good moral character in that requirement. And there is no record supporting petitioners' speculative assertions about the license review and adjudication process. So here what the state of New York is doing is also leaning heavily on the whole standing issue that was originally raised in this case, and that has, was also alluded to by the Second Circuit. Early on in this case, there was issues about standing. Even there, the district court judge, the lower court judge, Sotheby, found that the plaintiff lacked standing to bring this lawsuit. There he said that they would have to actually directly allege an intent to violate the law. But never was there an actual finding that they would have to subject themselves to the process. Here, New York is saying that there is potentially a lack of standing in this case because the plaintiffs here have not actually gone through the CCIA process. They have not been denied or approved based on good moral character. And so they're again kind of alluding to the whole standing issue and why this case is not ripe currently for Supreme Court review. So what does this all amount to? Well, what is happening here is that this is in some ways a strong case for Supreme Court review, but it also has a lot of hurdles that it has to get over. Although it's not the best procedural posture, again, this is a preliminary injunction review. It's a review wanting Supreme Court reversal of that injunction. This is a case, although it's in a weird posture, not a super favorable posture, it does deal directly with a law that was passed just 8 days after that Bruen decision. The CCIA was passed directly in response to what the Supreme Court ruled. And even there, the governor of New York was very expressly stating, just 8 days after that decision, that they were going to pass this law, the CCIA, in response to that Supreme Court ruling. And so all of that, all this historical backdrop, all of what is going on, the direct defiance to the Supreme Court, all of this leads to a strong case for Supreme Court review. But again, it still has to get over that hurdle that this isn't a preliminary injunction review. It's an interlocutory posture, but still, this is a case that is very important. It has huge implications for a lot of other areas like the Ninth Circuit, like the state of California with SB 2, and a lot of other states that are trying to put in place these concealed carry restrictions. So that's what's going on right now in the Antonyuk case and the challenge to New York's defiance of the Bruin decision with their new concealed carry laws. So if you guys like this video and you would like to support the channel, one of the best ways to do that is to like, comment, and subscribe. All those things help to fuel the algorithm, and it signals to YouTube that you guys see value in these videos and in this type of two-way news. But as always, thank you all for watching. Don't forget to like and subscribe, and never forget this nation was built by armed scholars, and this nation will be maintained by armed scholars.